Make sure you guys like, share, and subscribe. Thank you to everybody that has been coming to my channel. Like this video, share this video, and hit that notification bell so you guys know when I drop my next one. We are now reading part 4 of the Ryan Reynolds dismissal paperwork, and it is red hot with tea. The biggest question is how the judge will react to all of this since Justin Baldoni has essentially lost his entire career after these allegations went public. And now we're going to continue reading part 4. Make sure you guys like this video and share your comments below. And here we go. The FAC fails to plead any facts indicating that Mr. Reynolds' statements could be reasonably understood to have been an assertion of fact, capable of being proven false, rather than a pure opinion that is not actionable under the laws of New York. Court case cited. Let's continue. While the FAC fails to provide the sufficient details about the predator statement, which alone is grounds for dismissal, the limited context it does provide mitigates in favor of a finding that they are assertions of opinion. The FAC alleges that Ryan Reynolds made the predator statements during a phone conversation with Justin Baldoni's agent and at a movie premiere during a conversation with a WME executive, during which Ryan was expressing his deep disdain for Justin B., which is utterly fatal under the opinion doctrine, because it's plainly reflective of Ryan Reynolds' unabashed negative opinion of Justin Baldoni's character. Mr. Ryan Reynolds has a First Amendment right to hold Justin B. or any man who Ryan believes SH'd his wife in deep disdain, and the FAC does not allege any plausible facts that would remotely suggest, let alone establish, that anyone interpreted Ryan Reynolds' statements as reflecting anything other than his genuinely held belief about Justin B.'s character. The court should dismiss the defamation claim as to Ryan Reynolds with prejudice, because the predator statements are expressions of opinion that deserve absolute protection by law. Another court case is cited. The next section is titled, If the Predator Statements Are Not Opinion, They Are Substantially True. Even if the Predator statements were verifiable as fact, they are not actionable as defamation because they are substantially true. The Second Circuit has held that whether statements are substantially true is appropriate for resolution in a motion to dismiss, because falsity is an element of New York's defamation tort. And falsity refers to material, not substantially true. The complaint in this case must plead facts that, if proven, would establish that the defendant's statements were not substantially true. Another court case is cited. A statement is substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. Another court case is cited. Let's continue reading. When the truth is so near to the facts as published, that fine and shaded distinctions must be drawn and words pressed out of their ordinary usage to sustain a charge of libel. No legal harm has been done. It is not necessary to demonstrate complete accuracy to defeat a charge of libel, and all that is necessary is to demonstrate that the gist or substance of the challenge statements be true. Another court case is cited. Now, again, I'm going to pause there because the key thing in this situation is Justin B. has essentially, as of right now, lost a lot of income, lost his job, in my opinion, and has suffered humiliation as far as his reputation. So I don't know if this will hold up, but I'm eager to see what the judge says. And that's just my own personal opinion reading these documents. Let's continue reading. The FAC includes numerous references to conduct that a reasonable observer could well consider predatory. In particular, the FAC relies on Justin B's books Boys Will Be Human and Man Enough, and his podcast Man Enough, even going so far as to declare anyone who knows Justin would have knowledge of the contents of Mr. Justin B's book, relying on statements made on Justin B's podcasts. In ruling on a motion to dismiss, a court may consider documents possessed by or known to the plaintiff and upon which it relied in bringing the suit. Another court case is cited. Let's continue. The court may consider the full text of documents that are cited in, incorporated by, reference in, or integral to the complaint. Those materials with which anyone who knows about Justin B. would be familiar include numerous admissions to behavior that could reasonably be described as predatory. See Justin B's YouTube channel. Saying that I'm sure I have crossed boundaries and lines in my teens and 20s, not even thinking about it, simply because of the addiction I was consuming. The Man Enough podcast, and again, this is cited Jamie Camel, Changing the Narrative, the YouTube podcast of March 14th of 2022. I grew up and I had an addiction. I was introduced to that addiction at 10 years old, formed these neural pathways in my brain, and it caused me to see the world very differently. A Life of Greatness, Justin B. The Power of Being Enough, Apple Podcast, July 26th of 2021. And for me, it was really tricky because I believe that there's a link between our word culture and adult activity culture. I'm not calling out that adult industry. I'm calling out my relation to it. But I do believe that especially the adult industry that young boys are watching is very graphic. And because no one ever sits us down and teaches us about consent, we learn it through adult behavior. The Man Enough podcast, access to respect YouTube video, October 25th, 2021. You write as a black man or you as a woman have had to put up with a lot of stuff from people that look like me and or from me your entire life. And again, it could be laundry or it could be microaggressions for racism or sexism. Whatever it is, I've done all of them. Justin B., Man Enough, Undefining My Masculinity. I wanted as a man to claim her publicly, as on some level I knew it would make me feel more like a man, emphasis added. And these are his podcasts that were cited for this. While it is unclear what predator means to an average listener, it is quite clear that there is no discernible distinction between the gist of Ryan Reynolds' purported statements and the very behavior to which Justin B. has repeatedly confessed in public appearances, including that he spent years of his life mistreating women, which he attributes to a lengthy addiction to adult videos, as well as openly describing his distorted conception of consent in adult relationships. Were this case to go to trial, it would be Justin B.'s burden to prove the factual falsity of the supposed allegation that he is a predator. But the law offers no principal basis for a jury to distinguish that label from Justin B.'s descriptions of his own behavior. See another court case cited. Finding substantial truth where an article called Plaintiff and Adulterer, because an average reader would understand that term to include the admitted truth that he was a man who was unabashedly committed adultery for 13 of the last 17 years and whose adulterous behavior ended up only because his wife ultimately divorced him. Wow. See court cases cited. The statement substantially true where it thrusts was the same as the admitted truth. Another court case is cited. Find a statement describing plaintiff as a physically abusive pharmaceutical addict was substantially true given plaintiff's own admission about such behaviors. It would be perverse to permit Justin B to build an entire brand complete with a podcast, TED Talk, and books off of his confessions of repeatedly mistreating women, only to turn around and sue Ryan Reynolds for $400 million for simply pointing out in private what Justin B has bragged about in public, in light of Justin B's own public admissions, of which the court can take judicial notice. See another court case cited. Taking judicial notice of defendant's own statements made in public interview. See court case cited. Taking judicial notice of excerpts of books and articles written by plaintiff prior to alleged defamation attached to defendant's declaration due to their references to R-wording, SA, consent, and other Me Too related issues. The substantial truth doctrine requires dismissal of Justin B's defamation claims as to Ryan Reynolds. Wow, that was fully loaded. Next section. The FAC fails to plead special damages. Dismissal of a defamation claim is warranted because the FAC does not allege defamation per se, but nonetheless fails to fully and accurately plead special damages with sufficient particularly to identify actual losses. Defamation claimant must allege either special damages or defamation per se. Under California law, a plaintiff may only prevail if the publication is libelous on its face or if special damages have been proven. Now I'm going to pause right there because Justin has essentially lost his career. So there was actually a lot of damage done by the libelous claims that Ryan is tied to have made, in my opinion. But let's keep reading. This particularly requirement is strictly applied, as defamation claims will be dismissed for failure to allege special damages with the requisite degree of specificity. Far from fully and accurately identifying any harm that flowed directly from the injury to reputation caused by the predator statements, the FAC generally claims at least $400 million in compensatory damages without explaining what amount, if any, of the astronomical sum allegedly was suffered by Justin B. versus any of the other wayfarer parties, or otherwise caused by the predator statements. See court case cited. Finding failure to sufficiently plead special damages where complaint has neither pled its damages with particularly nor plausibility allege a causal connection between the alleged statements and a lost sale with FAC prayer for relief. Now I'm going to back up because this is where that $400 million could actually come into play. It took $25 million to make It Ends With Us, the movie, and it actually made $350 million, probably a little bit more after, digital sales or DVD sales or merchandise. They could actually say that because that little engine that could movie was actually made with only $25 million in gross $350, that $400 million claim would be reasonable, that a part two could have made as much or not even more because of how much the first movie made. So I do think that they could cite damages for the future movie because of how much the first one made and the damage caused by the statements. And I'm just saying, I'm not a lawyer, but that could come into play to substantiate a $400 million compensatory damage, because that's how much the first movie made. But again, let's continue to read. Let's just go back down. Excuse me. Find my place. I just lost my place. Here we go. This particularly requirement is strictly applied, as defamation claims will be dismissed for failure to allege special damages with the requisite degree of specificity, far from fully accurately identifying any harm that flowed directly from the injury to reputation caused by the predator statements. The FAC generally claims that at least $400 million in compensatory damages, without explaining what amount, if any, astronomical sum allegedly was suffered by Justin B. versus any other of the Wayfair parties. Okay, we read that. And going down here, on those amounts, in the amount to be proven at trial, but in no event less than $400 million. The court should strictly apply the particularly requirement and dismiss the defamation claim for failure to allege special damages with the requisite degree of specificity. And again, I do think that they could cite how much that movie made for the studio and how much damage was done to the studio in getting the second one made after the libelous claims went public. We're going to end right here, and we're going to continue with part 5 shortly. Please like, share, and subscribe if you have not done already. Share your comments below respectfully. And until next time, be safe and enjoy your day. Bye, guys.